Hello, this is Rocco Beatrice, Managing Director for State Street Partners. And now I'm going to talk about the limited liability company. It's a hybrid between a partnership and a corporation. It has the flexibility of the partnership because you can have multiple members, but it has the asset protection of the corporation, which says limited liability. In 1997, this hybrid device, the IRS made a decision that they were going to tax it as either a sole proprietorship, as a partnership, or as a corporation. Before that, all 50 states didn't know what to do. The IRS didn't know how to tax it. Was it a corporation? Was it a partnership? Was it a sole? In 1997, they made a decision they were going to do all three. The hybrid nature of the limited liability company, available to single members, multiple members, for multiple users, all type of businesses can use the limited liability company. It provides asset protection. The problem is, most people use it incorrectly. They use it as a single member LLC. Now, what's wrong with single member LLC? After all, the LLC is an asset protection device. It means that its owners are not liable for the problems encountered with running the LLC, similar to a corporation, limited liability. But the problem is that the stock, the membership units of a limited liability company, if owned by a single person, are considered to be personal assets, similar to owning 100 shares of General Motors, for example. When you go in front of a judge, he gives you two options. You either give him the stock or you sell the stock to pay your creditor. So single member LLC is not advisable. So how should you handle a limited liability company? Well, if it's with another device, usually with a trust, and the trust has to be irrevocable. The irrevocable trust owns the membership units of the corporation, of the partnership, of the limited liability company, of the sub-S. As long as it's owned by a third-party legal entity, they're not assets that a court can force to liquidate in favor of a creditor. The LLC also has another extremely important qualification. The membership units, the distribution of the profits does not have to be in conformity with the ownership interest of the LLC. For example, a corporation, if you own 25%, you're entitled to 25% of the profits. So too with a partnership. If you have a partnership interest of 30%, that is what's taxable to you. Well, not so with a limited liability company. It's extremely flexible. In fact, if you own 5% and all the other partners agree that 5% equity interest, you can, for example, allocate 75% of the profits because you're doing most of the work, the other partners are not. It's the only flexible device that you can do this. It does not conform to the equity membership units, but rather how, and this is all done with the operating agreement. The most important key element of a limited liability company is the operating agreement. The next is, where do you incorporate your limited liability company? Well, for years I used to use Nevada. Found it to be too complex. They changed the rules, and I like the state of Delaware because it has a better system protecting the debtor, the guy that owns the LLC, as opposed to the creditor. It's more debtor friendly. The default rules are in favor of the owner as opposed to the creditor. Most states, the creditor is king. Delaware, the default, that's why most people incorporate in Delaware. This is Rocco Beatrice, Limited Liability Companies. Go to our website for more reading, ultratrust.com.